This conference will now be recorded.
Well, good morning, everyone, and welcome to today's RHA Daily Webinar. For those of you that have been with us before, welcome back. Thank you for joining. For those of you that are new with us today, you can follow us on Twitter, and we do have our very own Facebook page. We also have our very own Roadway Live app, which is free to download to any smartphone. You can get the app via your app stores. Lots and lots of relevant information on there. We have traffic commissioners updates. We have updates on the new London Cleaner Air Zones. And we also have, more importantly, links to further webinars that we will be doing. If I could just remind everyone to keep their microphones muted throughout, as this is being recorded and will be placed onto the RHA website around about lunchtime today. For those who couldn't make it today and for those who wish to watch it again, it will be on there and free for everyone to use at their own time. Today's briefing then will be presented by Louise Moles, and we're going to be going through employment contracts and what they should contain. Before I pass over to Louise, I'd just like to ask everyone or remind everyone that the comments box is open for any questions, for any comments, any feedbacks, any ideas on future webinars, things that you would like to see. By all means, put it in the comments box and send it to me, the organizer. Just bear in mind, if you send it to everybody, everyone on this call today will be able to see it. So please just make sure if you want something private, just send it to me and I will get back to you after this webinar. So let's pass you across to Louise for today's presentation. There you go, Louise.
So good morning. As Darren very kindly introduced me, my name is Louise Moles and I'm the Regional Operations Manager for the RHA for Scotland and Northern Ireland. I have worked for the RHA for over 3 years, and today we are going to cover off contracts of employment and what they must contain. So there's 4 key elements that we're going to look at today. What are indeed contracts of employment? Why do we need them? What do they do? The statutory requirements. So there's 2 key pieces of legislation that are the platform to any contract or any employment regulation that currently exists in the UK. And what should contracts of employment contain? So we'll talk about express and implied terms and the sort of minimum legal requirements that a contract needs. So firstly, what is a contract of employment? In its simplest form, a contract is an agreement between employer and employee. It's like any other contract that exists. There are 4 key elements which must be set out in a contract of employment. A contract of employment is also known as a written particulars, and you'll see that phrase used throughout this presentation. The 4 key elements are the conditions of employment. So what sort of conditions will the employee be working under? The rights of the employee and equally the rights of the employer. You'll often hear many people say when it comes to employment legislation that it favours on the side of the employee. Actually, it favours equally on both sides and gives protection to both parties. The responsibilities of the employee, what are they there to do? What are you employing them for? What does the contract set out? The duties, roles and responsibilities of the post the employee has taken up. So we'll look at what should be included in those duties, roles and responsibilities. But one word of caution, I would keep it as flexible as possible. What this does is this allows you, the employer, sorry, if I can just ask you to go into mute. It asks the employee what their role is within the business. Now, these 4 conditions are known as terms of employment, and we'll discuss terms and conditions further. Now, both parties, employer and employee, must stick to a contract until it ends. So this could either be through dismissal or through giving notice. It's a legally binding contract, an agreement. In the UK, an employee is defined by the Employment Rights Act 1996. This is one of the pieces of legislation that is the platform to all employment rights and agreements and contracts that are set up. So it's someone who enters into work under a contract of service or apprenticeship. Contracts should consist of a mixture of express and implied terms. Why do we have contracts? Ultimately, it's there to protect the employer as much as the employee. It gives clear guidance on what the expectations are from both parties. So now we're going to look at these two terms, express terms and implied terms, and I'm going to give you some specific examples just to put it into a real life scenario. Express terms are terms that are given in writing and they are clear. They must be clear, concise and transparent. These can be included in other documents such as the staff handbook or various policies and procedures within your business. But what I will say is they must be accessible to all employees. Now, before drafting express terms, employers need to be familiar with the relevant law and up to date. This includes employee status, the rules governing written particulars of contracts, equal pay, national minimum wage, fixed term and part-time working, flexible working, which is becoming more and more popular in this world that we are living in, parental leave, and working hours. The express terms must comply with minimum legal standards such as the right to paid holidays and the right to daily and weekly rest breaks. Now, as I say, express terms must comply with minimum legal standards. Implied terms. So this is where it gets a bit juicy. Implied terms can happen under various scenarios. So when it's incorporated into a collective agreement, usually headed up by trade unions, by workforce agreements, so within the transport industry, night working, for example. It's also got to be incorporated in legislation. Incorporated into individual contracts by custom over. Terms can also be implied into contracts. This may happen because, and a couple of examples of this is a duty of mutual trust and confidence between employer and employee. So when you create a contract and you take an employee on, it's automatically implied that there's going to be mutual trust there. That's not something that really has to be written down. The right to receive at least national minimum wage, living wage. So again, you know, it's implied, it's expected that the minimum requirement that an employee will get is minimum wage. The right to a minimum period of notice. And the latest hot potato, equal pay for men and women. Again, this is an implied right. This is not something that really has to be written down. Now, I'd like to give you a personal example of implied terms and the difference. I think it gives a sort of real life working consequence of when this goes wrong. Many years ago, I worked in the car rental industry and I took on one of the top 5 Scottish airports, the British airports, sorry. And there was a supervisor that had worked there for many years. Car home, and a few weeks into the role, I spoke with her HR department and asked if it was in his contract of employment that he was indeed allowed to take a car home every night. They said there was nothing in his contract to say that he was eligible for a company vehicle, nor was he paying tax. So I investigated the situation, pulled the young man in, and he received the first written warning for taking a car without authorisation. The young man then continued to take a car home after his written warning. So again, pulled him in. He was given a final written warning. The day that he got the final written warning, he decided to finish his shift and walk out of the airport drive out of the airport in a Range Rover, which was probably the highest end car that was in the car park at the time. He came in the next day, and following the advice from HR, we had followed all of the correct procedures. I dismissed him. He appealed the dismissal. He won the appeal on the grounds that it was implied that he was allowed to take a car home every night. It was implied because for 3 to 5 years prior, nobody had ever questioned it. So it became incorporated into his contract, despite the fact what he was doing was essentially wrong. He went on to leave, and I believe he now works for Police Scotland. But that gives you a real life example of the impact of implied terms and if they're not managed correctly. Now, as many terms as possible should be clearly set out in writing and given to the new employee before or when they start their job. This avoids uncertainty or a dispute between the employer and employee regarding terms. So let's talk a little bit about statutory requirements. So on the 6th of April, there was 3 key employment pieces of legislation that were changed or updated. So it's called, the new statutory requirement is called a day 1 contract. Okay, so previously when you took an employee on, you had up to 2 months to provide them with a contract. From the 6th of April, it became on day 1. Right, so they have a right to have a contract or a written statement of particulars on day 1 of their employment. Now, contracts of employment are essentially governed by contract law. This means that they must hold the below 4 requirements. So an offer of employment from the employer, as we've said before, it should be clear, concise and unambiguous. It may be conditional. So for example, you would say subject to references or subject to a criminal check or a disclosure check. This offer must be accepted by the employee, whether that be in writing, response by email or signed contract. And the intent must be there to create a legally binding contract. So if we use COVID, for example, it could be that you sent someone an offer of employment and then the pandemic happened and everybody's business changed overnight. Now, the intent was there to create that contract, but due to extreme circumstances, you weren't able to fulfill it. Holiday pay. Again, the change was made on the 6th of April. So when previously calculating holiday pay, you would use a 12-week reference period. This has changed to a 52-week reference period. So when you're working out your holiday pay, think about the holiday year. So does it run from January to December, or does it run tax year to tax year? And that there is a whole new way of working out what an average holiday pay should be. Parental Leave Pay and Leave Act 2018. So again, this has been updated from April 2020, personally for the best. So parental leave no longer just applies to parents. It includes adopters, foster parents and guardians. It also includes more informal groups such as close relatives or family friends. So if you were an aunt that was the guardian of children or grandparents that were the guardian of the children, it covers you as well. Covers the loss of a child under the age of 18 or a stillbirth after 24 weeks of pregnancy. Now, employees with 26 weeks continuous service will receive paid leave at the statutory rate. Those with less than 26 weeks service, unfortunately, will not receive statutory parental leave, but may be able to claim through other benefits. It can be taken in one block or in 2 separate blocks of 1 week. It can also be taken within a 56-week window from the child's death. This allows time for moments such as anniversaries. Notice requirements have to be flexible, so leave actually can be taken without prior notice. The most important thing about this change in legislation is that at no point should an employer ever ask an employee for a death certificate as proof of evidence. And as an employer or an operator, you would put yourself in a very sticky position if you did that. It's an emotive subject, it's a highly sensitive subject, and therefore it should be treated as such. So let's look at what must be included in your contracts. So the following are minimum legal requirements. So the name of the employer and the employee, the date of commencement of employment, notice period, whether that be employer giving employee notice or vice versa, the rate of pay and the method of calculating this. Particularly in transport, we have various different methods of working out rate of pay. So it could be a daily rate, it could be that it's a 45-hour contract with guaranteed overtime. You have to make the method of which you calculate the pay really, really clear. At the end of the day, when it comes to contracts of employment, both parties should never be surprised. The pay date, so whether it's weekly, monthly, specific date, the second last working day of the month, that has to be clear. And let's be honest, it's the reason that we're all working. Terms and conditions regarding hours and days of work, variable working hours. So as an example, it may be that you expect the employee to work Monday to Friday, 8:30 to 5:30, and every third Saturday morning. That has to be set out and it has to be clear. If it's shift working, you also have to make sure that they are aware that they're expected to work bank holidays, whether it be 4 on, 4 off, however you operate your business. Terms and conditions regarding holiday pay and bank holiday working and how this is calculated. So as an example, if I go back to the airport days, the airport runs on a 365-day, 24/7 scale. That is the cycle that we work to. Transport is very much the same. Therefore, it would be sensible that you would have your 20 days holiday allowable for your staff, plus 8 days bank holiday. So you would say to your staff, right, you've 28 days a year. That has to be clear. It should include a job title, so brief description, and keep it brief, because the more rigid it is, with the less flexibility, the more conflict you may come up against when you ask employees to do different or various work or cover colleagues. So a brief description of the sort of work the employee is expected to do. The place of work and address of the employer, if remote working, details as such. So for example, I cover Scotland and Northern Ireland. The expectation is implied that I will travel a lot. However, the express term is that I'm on a home-based contract. Any other benefits which are not covered elsewhere. If contract is key time or fixed term, details are expected of the sort of engagement that will be required. So for example, if you got a new contract that was to last 3 months, you would state in the contract of employment that the contract will run from May to August with a view to potential extension if the contract was to run over. So keep it as flexible as you can. Probationary period. So let's talk about probationary period for a second, because it's all good and well having a 3 or 6 month probationary period for your employee. However, as an employee, nothing should come as a shock. So it shouldn't be that the employee gets to the 6 month mark and they're dismissed or the probation's extended. They had to have seen it coming down the track. So I encourage monthly one-to-ones, progress reports, so that nothing is seen as a surprise. The other thing that must be included is training. whether that's compulsory or non-compulsory. For example, our drivers have to do their 35 hours driver's CPC every 5 years. Transport managers, on guidance from the Traffic Commissioner's Office, should be doing their Transport Manager refresher every 2 years. So that should be included in a contract as well. With regards to supplementary information, so these can be in the body of the main contract, or they can be placed in various policies and procedures or staff handbooks that you have. As I said before, they have to be accessible to the employee at any time. Whether that be terms and conditions of sick leave and pay, terms and conditions relating to their pension. So you do have 2 months to supply this, the first 2 months of their employment, to supply this to the employee. The other thing that you have 2 months to supply is collective agreements. Any other training entitlement, so it may be a role-specific training that they must do. The disciplinary and grievance procedures, and any other paid leave, for example, bereavement. So the Employment Rights Act 1996 states that all these items included in written statement of particulars, this isn't just the contract, this is the handbook, the policies, the procedures, anything that you hold as a business must include, and this list is certainly not exhaustive. So if it's a subject matter particularly related to your business or your industry, feel free to create a policy that sits behind that. Disciplinary rules and procedures, so these have to be known. Sickness. That's sickness reporting, absence reporting, along with sick leave. Any detail relating to bonus, overtime and commission structures. Collective agreements. Other terms such as private healthcare, overtime, holiday arrangements or retirement. What happens if you have to make a change to a contract? So there's 3 options that you have. The first one is your safest one, the next 2 are risky. So let's look at the safe option. Employer and employee agree the changes through a consultation. Now, as an employer, you can offer a small incentive to encourage the employees to accept this, but just watch that it doesn't look like bribery. So the small incentive may be, we're changing you from 6-day-a-week working to 4 on, 4 off. Well, as an employee, you'll save on fuel, you'll save on childcare, you'll save on, that's an incentive. This is, of course, the safest course of action. Make the change unilaterally. So this is risky, and you need to be aware of the risks associated with this. Even when there's a business case to impose these changes, the employer may assume acceptance if the employee continues to work without objection. Or it may be that your employee works but protests and ultimately brings a claim forward. Or worst case, they resign, claim for constructive dismissal or wrongful dismissal. So you have to be really, really careful when making changes to contracts. The third option is to terminate the contract by notice and offer re-engagement on new terms and conditions. But please be aware, this could be deemed as redundancy dismissal, so follow the rules around collective redundancy and consultation timeframes. Again, this option is not without risk. And lastly, the RHA can help. So we offer contracts of employment. We can do that as an organisation to you, the operator. And if this is something you're interested in, please feel free to give me a phone to discuss it further or to email you. Thank you for your time.
Thanks, Louise. Lots and lots of good information there. So please, if you have any comments, any queries, any feedback, please by all means use the comments box. Our next webinar will be on Thursday, and where we were discussing clean air zones and the impacts that this is having on operators. So all that's left for me to say is thank you very much for those who attended today. Very much appreciated. If you want to watch this back later on, as I said at the start, the webinar will be online from around about 1 o'clock today. So you'll be able to watch it. And if you have any questions, again, by all means, please feel free to use the comments box. So all that's left for me to say is from everyone at the RHA, thank you for your time today. And I look forward to seeing you all again on Thursday. Thank you.